Dear students, in this video we'll talk about some important differences in the trial. So we'll do it in certain pattern. You need to go through the whole video thoroughly and then you will be able to understand what exactly it wants to say. Do not get confused, just memorize and remember the concept. So point of difference, source of trial. When we talk about session trial, then it is police report. Magistrate trial on police report, then it is police report. Magistrate trial other than police report means complaint case is there, complainant is there. In someone's trial, complainant is there. Now even cognizance is taken by magistrate in a suo motu way, still relevant process is to be complied with. If you read the section 190 of C.R.P.C, then you will see that cognizance of offence by magistrate. So cognizance can be taken upon receiving a complaint of facts, upon police report, or upon information received from any person. Okay, any person other than police officer, or upon his own knowledge. So suo motu action may be taken. Now cases are being placed before court by public prosecutor when it comes to warrant trials. But when it comes to summon trials, the complainant goes and complainant himself by permission of court may pursue his case, or he can take advocate of his choice also. And this session trial, police report, and how cognizable, non-cognizable cases takes place, that we have done already in previous videos. Now the option of discharge. Session trial 227 we have done in previous video also. A magistrate trial 239. Here 245 1 allows. Now what is the difference? The difference is 245 clause 2 allows discharge at earlier stage. First line of 246 clause 1 also makes it clear. So 245 says that nothing in this section shall be deemed to prevent a magistrate from discharging the accused at any previous stage of the case. So it talks about all the evidence is referred in 244. 244 says that magistrate shall proceed to hear prosecution, take all the evidences, and clause 2 says on application issue summon to any of the witnesses directing him to attend. So after this or before completion of this step, magistrate can discharge the accused. Now read 246 clause 1 first line what it says. If when evidence has been taken or at any previous stage of the case, okay, when evidence has been taken by 244 by virtue of 244 or at any previous stage of the case, clause 2 is talking about the same thing, the magistrate is of opinion there is a ground that accused has committed an offence. Okay, so if he thinks offence is committed, then he will pursue with the matter. If not, he will discharge. So if he accused is discharged, it will be discharged at this stage, and if not, then magistrate will pursue. So 246 also talks about the two things, when such evidence has been taken or at any previous stage. And section 258, a little difference which we have covered in the previous video. Now third difference comes to be framing of charges. Section 228 it is mandatory, 240 mandatory, 245 mandatory. However, section 251 summon trial says framing of formal charge is not necessary, it is optional, and usually it is not framed, and there is a specific format in the court which they follow and they do it accordingly. Then plea guilty. 228 talks about plea guilty in court, 240 talks about plea guilty in court, 246 talks about plea guilty in court, and 251 also talks about. But 253 allows to plea guilty by post or pleader, means accused need not to be present there. Now when you go to the court, you will find certain variations. Most of the time you will find certain variations, and that is because of the practice which is being followed in the court by virtue of inherent power of the court. So need not to worry about that. Now 249 says if complainant is absent, then only accused may be discharged. It says absence of complainant, which we have done in the previous video also. Such option specifically is not there in the other trial, but here it has been given specifically. So this is again a point of difference. Look, in practical, in reality, when you go for internship or you go to the court, you will find that serious matters are being taken up in a serious way, and non-serious matters, so process is not that strict and lengthy. It is a matter of thing which you can only learn by practice and by going to the internship. Here you can just assume, presume and learn and understand the provisions. Now prosecution evidence. Stages of taking prosecution evidence varies by nature of the trial. Into section 230, this we have done earlier. It is taking prosecution evidence is a common point, as well as there is variation because at what stage you are taking the prosecution evidences. Now if you see magistrate trial other than on police report, evidence for prosecution is taken at the commencement of trial. And summon cases, it says that if accused is not convicted or plead guilty, then prosecution evidences will be taken off in detail. Apart from other trials, these are the similarity, and then you can also see them as the differences. Now acquittal, 232 is a stage which allows acquittal. So in session trial there are two chances of acquittal, one as per 232 and other after taking all the evidences, but no such provision is there in other trials. Then for arguments also, which we have done in the previous video, you can see this is a stage of trial and no such provisions are there. However, magistrate may allow, and usually advocates many times they plea also to sum up and wind up the case. So that is also happening, but it depends upon particular court to court. Now compensation for accusation, no specific provision in any of the trial other than summon trial. Section 250 provides for granting compensation. It says if magistrate is of opinion that there was no reasonable ground for making the accusation, there was no reasonable ground, and without any reasonable ground accusation was made, then magistrate may call the person, the complainant or informant. If he is there, he will call. If he is not available, then magistrate may summon the complainant and informant, and then magistrate will ask him to show cause that why he should not pay the compensation to accused person or persons. If one accused is there, accused person. If more than one accused are there, accused persons. Then withdrawal of charges. No such provision is there in any of the trial, but 257 talks about. 257 says withdrawal of complainant. Now the condition, if a complainant at any time before a final order is passed, okay, before the stage of final order, complainant may satisfy the magistrate that there are sufficient grounds for permitting him to withdraw. So accused, this complainant here wants to withdraw his complaint. For that he has to satisfy the magistrate by providing the sufficient grounds. For example, there is something wrong with identification of the accused. So now magistrate may permit him to withdraw the same. Now here we can also see one more difference, that is 258. It says power to stop proceeding in certain cases. So in summon cases instituted otherwise than upon complaint, then magistrate with previous sanction of CJM or any other judicial magistrate as allowed, he can stop the proceeding at any stage without pronouncing any judgment. So if he is stopping the proceedings, he is stopping the proceeding after taking all the evidences, then he will give the judgment of acquittal. Otherwise he will release the accused and such release will have effect of discharge. So now in summon cases instituted otherwise than on complaint, magistrate of first class or with the previous sanction of CJM, any other judicial magistrate, that is judicial magistrate second class, earlier I said something else, forget about that and focus on this. In any summon case instituted otherwise than on complaint, okay, a magistrate of first class or with the previous sanction of CJM, any other judicial magistrate. Any other judicial magistrate means judicial magistrate second class. Or there may be chance that special magistrate is there and he has to take permission from CJM if there is any setup, then only. So first class or other judicial magistrate, they will record their reason in writing and they can stop the proceeding at any stage without pronouncing any judgment. Now there are stages. If proceeding has been stopped after taking evidence of principal witnesses, all the evidences have been taken, then there will be a judgment of acquittal. But if proceedings has been stopped before this stage, then he will release the accused and such release shall have the effect of discharge. Again, this is a point of difference. So I'll simply write here discharge, which we have done earlier also, but here it is in the sense of section 258. Now moving further, we'll deal with difference between warrant trial and summon trial. A bit different thing may be there. Now warrant trial, so we have covered warrant trial which is happening on police report and other than police report, which is happening in session court or in magistrate court. So we have summed up the warrant trial on one hand and then summon trial on the second hand. So let's see. So here warrant trial follows two procedure. Cases instituted on police report, cases instituted otherwise than on police report. Warrant cases which are punishable exceeding 2 years. Okay, section 2, go with the definition which we have covered earlier also. And then summon trial is followed in summon cases. Okay, they are also, we have also discussed what are summon cases, being punishable not exceeding 2 years, and you can see the schedule also, the definition and schedule of the Bail Act. So in warrant trial usually graver offences are dealt with, hence the trial is lengthy and slow also, that you will see in practice. You will also see the stages of cross-examination. Usually in warrant cases they may get chance of cross-examination, but in summon trials the chance, and even in cases instituted in magistrate court other than on police report, chances of cross-examination is less. Now it depends upon other factors also, because there is no straitjacket formula to say yes or no when cross-examination is required. Here we are talking about cross-examination means once cross-examination has been done and party again want to cross-examine the same witness. So court asks that why you did not do it in the first stage. Now accused gets more than one chance to cross-examine the witness, which I was just talking about, and accused get only one chance to cross-examination. However, it depends, but for the purpose of academics and for the usual course of action, you should remember this. Unless you have a good reason, court will not allow you. Then warrant trial cannot be converted into summon trial, but summon trial may be converted into warrant trial if magistrate feels so. Now if we see here in session trial, suppose case is happening in session court, and session court realize that it is comes under the jurisdiction of magistrate court. We have done the power of the magistrate courts and session courts, we have done the power and their jurisdiction also. So if session court thinks that it falls in under magistrate court, he will send the case. And if magistrate court is dealing with a case and magistrate finds that this matter pertains to session court, session trial, so he will commit the case to session court. Now listen to it carefully and read it carefully. You cannot just run over these provisions and memorize them. No, you need to give the time. A focused study will allow you to understand it. If you understand it in the first instance, that would be good. Otherwise you will get confused. So don't get confused. Just listen and memorize it. Understand it. Now framing of charges is necessary, but framing of charges is not necessary in summon trial. Now warrant trial contemplate participation of police. Even in complaint case, magistrate may seek for investigation. This investigation is different from power of police to investigate, which we have done in the previous lectures. And summon trial does not contemplate participation of police. Now summary trial. We have not covered it, summary trial. We have not covered the summary trial in previous lecture, as well as in the current lecture where we did difference. But now by reading this you can easily make out the difference. Now summary trials are the trials which are speedy disposed, cases which are speedily disposed and with the simplified procedure of recording the trials. So summary trial implies that a case is tried and disposed at once. Speedy disposal of the case. Such a trial is not available to cases which are complicated and require lengthy process of inquiry. Now who has power to try the case in a summary manner? Now I'll take you to section 125 Cr.P.C also, because it disposes the matter in a summary way, the maintenance matter in a summary way. So you can create an analogy by understanding that also. Now coming to 260. Now this summary trial, it runs from 260 to 265. Then 265A you have plea bargaining, that is a different concept. So section 260 says any CJM, Metropolitan Magistrate, MM, Magistrate first class empowered by High Court has power to try certain cases. CJM, MM and Magistrate first class, if empowered by High Court, they can try the cases in a summary manner. Now what are the cases which can be tried in a summary manner? So there is a list in which you have 10 offenses which you need to learn. There is no other way, but you have to learn it, remember it. First says offenses which are not punishable with death imprisonment. I'll tell you in shorter way. Offenses not punishable for more than 2 years. Now listening summary, you cannot say that it is a matter of right. You cannot say it is a matter of right. If you see section 260, it says that these are the authorized courts. They may, if think fit, try in a summary way all or any of the following offenses. These offenses, so may word is there, means it's a discretion, judicial determined discretion. So one cannot ask to get the matter tried in a summary way as a matter of right. So offense not punishable for more than 2 years. Second is value of stolen property not exceeding 2000 rupees. Third is as to section 411 of IPC, Indian Penal Code, value of property not exceeding 2000 rupees. And as to section 414 of IPC, value of property not exceeding 2000 rupees. And as per offense under section 454 and 456 of IPC, offense which are embodied under 454 and 456 of Indian Penal Code. And then offense to provoke breach of peace under section 504 IPC, Indian Penal Code. And then criminal intimidation under 506 IPC. I am telling you in brief, you can read it in the simple language. This is not the barrack language, this is the simple language. So you can pause the video and you can see. Any abatement of above mentioned offenses. Any attempt to commit the above mentioned offenses. So abatement, attempt and offense which comes under section 20 of Cattle Trespass Act. These are the instances which may be tried in a summary way. So the same thing, that if magistrate due to nature of offence thinks that a matter should not be tried in a summary manner, he may proceed with other manner as provided in the court. Now section 261 says magistrate of second class, if empowered by a high court, may also try the matter in a summary way. Now 262 it talks about what is the procedure which is to be followed for summary trial. So it says procedure of summon cases is to be followed in summary trial. Okay, so it was not viable to keep the summary trial with the comparative chart and differentiation chart, but one thing is very much clear here, that this is a category of offences which can be tried in a summary way, and the theorized courts have also been portrayed. Then there are also certain things which are different in summary trial, although the process of summon cases is to be followed, and as per section 262 no sentence exceeding 3 months can be passed in a summary trial. This question is asked at interview stage also. 264 judgment in case tried in a summary manner. So it says in summary trial magistrate record only substance, core and conclusion of evidence, and judgment is recorded briefly as against other trial. However, usually in trial courts the judgment is not that lengthy. However, if matter is serious, then obviously it has to be accordingly. If session trial is giving someone capital punishment or life imprisonment, then obviously that shall contain relevant detail. And since natural justice is also there, all the judgments have to be reasoned one. Now difference between summary and regular trial. So this will clear, three differences are there, and this will clear the things. It says that a summary trial can be conducted only for specified offences, indeed, which are minor in nature. We have gone through the list, whereas more complicated and serious nature offences are tried in regular trials. So you can understand that once look, you also do number of tasks on daily basis, and there are some serious tasks and there are some non-serious tasks, but both of the tasks are important. So think how much time you give to important task and less important task. However, both the tasks are important, but amount of time and amount of resources you deploy, you give for both of your tasks is different. So as I already said, when you go to court you will understand it. Now here you can try to understand and assume and presume it accordingly. In summary trials, only the substance of evidence and the disposition is briefly recorded. But in regular trials, evidence is recorded carefully and in full. However, in summary trials also it is done carefully. But the word carefully here only signifies the gravity of the offence and nothing more than that. Now, no formal charge is required to be framed by magistrate in summary trials, and again in summon trial also, because summary trial follow the cases of procedure of summon trial, but a formal charge sheet is required in regular trial. So here we go. So I think this would be helpful up to a certain extent, and with more videos we'll meet again. By the time, best wishes.